So I just provided some information on just some statistics for people to have a general sense about what we're talking about when we talk about immigrants in the US, immigrant families. And so I just provided a bit of information showing, this is also kind of useful for like cocktail parties when you talk about immigration and show people all that you know. But right now we have about 39 million foreign-born people in the US, which is about 12.5% of the population. For some people you may be surprised that it's that high. For other people feel like, oh, I thought it was way higher than that. So that's part of the reason to give that info. Current estimates are that about 11.2 million of those people who are foreign-born are undocumented. And again, we'll go through later what it means to be undocumented, but basically people who are here without lawful immigration status. I threw the statistic in there on asylum because there's often a sense that the US is like the largest magnet in the world for all immigrants. And the reality is not that way, that we do have a large immigrant population, but that migrants worldwide are a huge population, many of whom do not ever make it to the United States, but migrate to other countries around the globe. This is a bit about, more specifics about children. What you'll see there is you have about 17 million children aged 17 and under that had at least one immigrant parent. And so it's actually a pretty substantial number of all children, a high percentage in that age group, who have at least one foreign-born parent. And like we mentioned, or I mentioned earlier, a lot of the families, immigrant families, are mixed status families, about 86% of them. So very frequently when you run into immigrant families, you'll have people who have different immigration status. You may have a child who's a citizen, a parent who is undocumented. Conversely, you might have a lawful permanent resident parent who's been here a long time with a child perhaps that they left behind in their home country and who's recently arrived and may not have status here. So it's just one thing to keep in mind when you're working with families, that it's important not to presume that because you know the immigration status of one person that you can make conclusions about the immigration status of everyone else. And so in a minute we'll go over some documents you might be able to look at and ways to figure out what really is this person's immigration status, partly because particularly with children, sometimes the children don't know what their immigration status is, and so it takes a little bit of digging to try to figure that information out. Now, where Nebraska fits in is sort of interesting. I think that Nebraska is considered more of a new growth state for immigrants, and meaning that the sort of immigrant population and growth of the population is something that's more recent than you might have had in other states like New York or California. So a lot of the things I'm going to talk about today, I have tried to make Nebraska specific, but what you'll see, there are certain states, California, New York, that have had a much longer time of dealing with high numbers of immigrant children in the child welfare system. And so there are certain practices that have developed that might be useful for you to know about. Some of them are not replicable here or wouldn't make sense to replicate them, but just the idea that there are some court systems that have more of a history of dealing with these issues, really because it's reflective of the population growth there. So what you'll see is that there's a relatively small number of foreign-born people in Nebraska, and I've given you a breakdown on the numbers or the percentages. It was estimated in 2005 that approximately 35,000 to 55,000 undocumented people lived in Nebraska. Now again, this is 6 years ago, and it's difficult to make estimates about the undocumented population because it's hard to figure out exactly how to pin down those numbers. But those are the overall numbers. Another thing to know is that in terms of people who lawfully immigrate in the US, back last year in 2010, you had about 1 million people who became lawful permanent residents, and only 0.4% of those people were in Nebraska. So a really small number of people in Nebraska, about 4,000, a little over 4,000, became lawful permanent residents last year. And you also, oh, this is a slide I just went over here. The information on the previous slide that I had talked about, that Nebraska ranks 29th in the nation in terms of percentage of foreign-born people, and 38th in the total number of foreign-born people. And then there were just some estimates about the number of foreign-born people here and the percentage of the growth. And so what you'll see is that the absolute numbers of foreign-born people in Nebraska are not huge, but the percentage growth of the population really outstrips a lot of other states. And then specifically on children, I just gave some statistics on the percentage of children in different age groups who are foreign-born in Nebraska. And what you'll see is that, generally speaking, the younger the child, the more likely it is that the child was born here in the United States. And so in the age group of children younger than 5 in Nebraska, you only have about 1% of those children who are foreign-born. The older that they are, the more likely it is that they came to the United States either alone or with their parents. And so it's something to just keep in mind, that the older a child is in the system and is in an immigrant family, the more likely it may be that they were born abroad. But again, the numbers are still really pretty small. And so I did a little research, and I pulled up some numbers from the Nebraska Foster Care Review Board, and saw that at the very end of 2009, there were about 4,500 children who were in out-of-home care in Nebraska. So if you run the percentages based on these figures here, what that means is that you have a relatively, or would have a relatively small number of children in out-of-home care who are foreign-born. You would be looking at about maybe 127, 130 children who are in out-of-home care. And so what that shows is that it's not a huge or overwhelming number, but it's a substantial enough number that it's worth knowing about immigration issues. And actually, in a way, it's a manageable number in terms of really affecting some change for those kids in their immigration status, because it's not an overwhelming number of children who need these immigration legal services. And one thing I think that's important to think about as well, and I think you mentioned the issue of adoption of immigrant children. We're going to talk a bit about really tricky immigration issues that can come up when you have an adoption of a foreign-born child. And they're really important issues to think about before you finalize an adoption for a child. The number that I had from, let's see, it was 2009, was that there were 487 adoptions of state wards in Nebraska. And so what you're looking at there is, if the statistics again play out, maybe 29 or 30 children who were foreign-born who were adopted. For those 29 or 30 children, it is crucial that there be thought given to their immigration issues before they're adopted. And that's for the children's own well-being, but also for the sanity and happiness of the adoptive parents who, if they adopt a foreign-born child without the proper immigration steps having been taken, find themselves in an incredibly difficult situation where the child they thought was a US citizen is actually an undocumented person who could be deported. And so we'll talk in some more detail about how those issues come up and what you can do to prevent that problem from happening. Okay, so the immigration system. You might hear people talking about the INS still, that people say INS came to get me, or I applied to INS for something. The INS ceased to exist back in 2003. You may still hear people using those terms, but really now the immigration functions of the federal government are handled by the Department of Homeland Security. It's not all that the Department of Homeland Security does. There's FEMA, there's GSA, they have all of these other functions, but within the Department of Homeland Security, there are three parts of the agency that deal specifically with immigration. And so those are USCIS, and CIS is sort of the relatively happy part of the immigration system, where you really, if you have to deal with DHS at all, Department of Homeland Security, you really want to be dealing with CIS. These are the people who are the givers of immigration benefits. So if you're applying to become a permanent resident, if you're trying to naturalize and become a citizen, CIS, these are the people that you want to be dealing with. The part of DHS that is the less happy part for immigrant families is US Immigration and Customs Enforcement. And this is the part of DHS that does immigration enforcement within the United States. So if you have families or parents who are picked up in raids at workplaces, it will be ICE that will be involved in those raids. They're also the people responsible for maintaining the detention system for immigrants within the US. Custom and Border Protection, CBP, is the last part of DHS that deals primarily with immigration. It's, I think, less likely that you would have interaction with CBP on your cases. They are primarily, they function at borders and ports of entry. So we think of them typically as Border Patrol down at the US-Mexico or US-Canada border. They also, though, work at the virtual borders in airports. So when people are entering or exiting the US on international flights, and you may not know this when you go, but you are actually at a border point and subject to different laws about search and seizure when you're at the border, and the border being the international airport. So if you have had some families who've immigrated come into Nebraska through an international flight, then they may have had some contact with CBP. But the people we'll be primarily concerned about today are CIS and ICE. And the Department of Homeland Security also works with the federal Department of Health and Human Services, and also with the Attorney General in collaboration on some immigration issues. For some folks, they are unfortunately dealing with the immigration court, or the arm of the federal government that deals with adjudicating people in removal proceedings. And so that part of the government is the Executive Office for Immigration Review. And they run the system, or are the system, of immigration courts around the country. And also there is a Board of Immigration Appeals, that's the appellate body for immigration courts. And then you can also, a person could appeal their removal order, if they have one, up to the Federal Court of Appeals for the area that they live in. So for all of you, that would be the 8th Circuit, is that right? So for any of you who are interested, I believe, and for some of you who do immigration work, I think it was back in 2008 that an immigration court was created for Nebraska. My understanding is that up until that point, the cases were heard in immigration courts outside of the state. But now you have your own immigration court, 2 judges in Omaha, and I think a 3rd judge who teleconferences from Chicago. And so if you find yourself, if you live in Omaha, or you find yourself in Omaha, it's actually an incredibly fascinating and eye-opening trip to take to the immigration court to watch some immigration proceedings. People who are seeking asylum have the right to have their hearings closed for confidentiality reasons, but otherwise the proceedings are open to the public. And it's a sort of fascinating and often depressing place to go. But for any of you who work with immigrant families, it's really worth taking a look, because what you'll see are the high numbers of cases that are handled. People have no right to government-appointed counsel in the proceedings, so you'll see many people trying to represent themselves and having a difficult time doing it. You may also see people who are detained in immigration facilities around the country or around the state being video conferenced in for their hearings. And so it's really worth a look. I think that the immigration court now in Omaha unfortunately has the honor or not of being the immigration court with the 3rd largest backlog in the entire country. So the amount of time it takes for a case to go from start to finish in Omaha now, I think, is about 511 days. So it's something for you to be aware of. The detained cases move faster, but it's something for you to be aware of if you're working on a case where you might have a parent who's in removal proceedings. It helps to have some idea of what is the timetable for these cases. And so you should just know that generally these cases can go on for a very long time. And I've litigated cases in immigration court that have gone on for 3 or 4 years. So the kind of cases, at least in LA in our court, when you get a continuance on an immigration case, your continuance may literally be a 6-month continuance. The judge will say, come back in 5 months or 6 months. Sometimes they'll say, come back in 2012, June. And so it's just a very different court system that you're dealing with, and it's worth seeing, but also just having a bit of a sense of how that operates. And there are some cases that do move more quickly, as I mentioned, but right now there are over 4,000 immigration cases pending in Omaha. And again, this is for 2 full-time immigration judges and then a video conference in. So it's just for you to be aware of the sort of numbers that people are dealing with in these adjudications. Okay, so we're going to talk now about different kinds of immigration status, but before we do, I just want to point out to you that in the materials that you have on the pages 1 through 4 is a organizational breakdown of the Department of Homeland Security. So if you're interested, you can get a sense of what are the different parts of DHS, how do they fit together. All right, so the first thing we'll talk about, we'll start with US citizens. I think that that's the immigration status that is the most promising for everyone. It's the most straightforward in a way, and also if you're working with a child or a parent in juvenile court, if they're all US citizens, then a lot of the immigration issues that we'll talk about will not need to worry you. Now, most people realize that folks who are born in the United States are citizens at birth, with the small exception of children of diplomats. So you need to be in the US and subject to the jurisdiction of the US to be a US citizen. So if you have any cases where maybe you have parents who are undocumented, don't have status here, but their child was born here in Nebraska, that child is a US citizen. And even if the parent may be confused about that or may not realize that that's the case, as long as the child was born here, the child is going to be a US citizen. And there are some other rules about Guam and Puerto Rico. Well, Guam and Puerto Rico are included, US Virgin Islands, and then there are some special rules about the Panama Canal Zone. And if you have a case like that, you can call me and we can talk in more detail about the Panama Canal Zone. But one thing that's important to remember is that US citizenship is not just for people who were born in the United States. And I think this is something that's important to remember for cases that you're handling. If you have a child who was born abroad, chances are that child is not a US citizen, but it's also possible that the child is actually a US citizen. And so there are some pretty specific rules about when a person would be a US citizen if they're born abroad. So what you want to do is just pull out your materials at page 5. And I've got a redacted birth certificate here, and we'll just walk through how this particular rule may apply. So this is a California state delayed registration of birth. And it's something useful to know about. This is a birth certificate that was registered in California, but it's a child who was actually born abroad. So it's something to be aware of. I don't know how often it happens in your cases, but there are definitely issues that may come up when you have a child who's born abroad. One issue may be that you need a birth certificate for the child and you don't have one in the file. You're trying to figure out how to do it. Has anyone had to get birth certificates from abroad?
Well, I actually have a question.
Yes, yeah.
Because I've dealt with a couple of cases where we've had parents, one parent, the mother, who is a United States citizen, born in the United States, left and went to a foreign country, Mexico, in one of the particular cases, had a baby while they were in Mexico with a Mexican father, didn't get the certificate of birth abroad, didn't do anything, somehow was able to bring the baby back into the United States with no paperwork. Mom is now AOL, don't have any idea where she is.
Right.
And we don't know what to do. We can't get a birth certificate because the Health and Human Services says, well, we can't give a birth certificate for a child who's not born in Nebraska.
Right, right.
But without a certificate of birth abroad, I've been told I can't get any kind of citizenship papers for the child.
This is a complicated situation. If you know that there is, and this is not your case, if you know that there is a birth certificate floating out there abroad and you just don't have the copy of it, many people think, oh, let's go to the consulate, let's go to the embassy of that country in the United States and try to get birth certificates that way. And that's certainly worth trying. In my experience, I've found that contacting the civil registry in the country of the child's birth and requesting the birth certificate there is actually a more efficient way to get your hands on a birth certificate for a foreign-born child. That often, because the civil registry there is the agency that is dealing with registering and issuing birth certificates, and often if you cut out the middleman of the consulate and go straight to the civil registry, you'll have to work out how you're going to pay for the certified copy and have it sent to you. But it's a good way to go. So in cases like that, I always do a search with the civil registry just to make sure that there's really not a birth certificate there. When we have cases like that in California, and again, this may be a difference between California and Nebraska that is going to be more difficult to handle. What we've been able to do, at least in California, is to get a court-ordered delayed registration of birth for a child who was born abroad, as long as there is a court hearing, a petition filed in a court hearing where the juvenile court judge is satisfied they can establish the fact of birth, even if the fact of birth occurred abroad. So that may or may not be something you could do in Nebraska, but certainly if you could, you would get something that looks more similar to this. It wouldn't, it's not a document from abroad, but at least it would be some kind of identity, some kind of birth document for the child. Alternatively, if you can't do that in Nebraska, if there's anyone in the child's home country who could register the birth, either some extended family member, grandparent, who could go in and do a delayed registration of birth, that's another way to get the birth certificate for the child. I think in your case, what may end up being interesting is whether the child may actually have been a US citizen at birth in Mexico. And if that's the case, then you would want to get together some kind of birth document, whatever you could, so that you could apply for a certificate of citizenship with US Citizenship and Immigration Services. They would just want some documentation of where the child was born, and if you have that and the mother meets these other requirements, then you may be able to get a certificate of citizenship and then a US passport for the child. But those can be tricky when you don't have any identity documents at all. And I think in this case, this was a situation where the child's birth had not been registered abroad. I think there was a baptism certificate, but that's all there was. And so this document was created to at least have some information for the child. So if you take a look at this, and you presume that this is not an adoption case. These are the biological parents of the child born in Mexico. The first question is going to be, this is redacted, but the first question is, what is the citizenship status of the mother and the father, based on the information that you have here? And it's not a trick question. Everyone yesterday was like, I don't know the answer. U.S. citizens. So what you'll see here, you have the father born in California, mother born in Connecticut. Those people are U.S. citizens. The child's born in Mexico, so the question is going to be, what is the situation for this child? Now, if you look at these rules and you presume that these two U.S. citizen parents were married, they were married and they went to Mexico, had their baby in Mexico, then the question is this child a U.S. citizen? So the question you would need to ask then is, did at least one of these parents reside in the United States at some point prior to the child's birth? If the answer to that question is yes, then the child is a U.S. citizen, even though that child was born abroad. And so in this particular case, you would need, and you almost always need a little more information than what's on the face of the document, but at least you would know to refer the case to an immigration attorney who could do that analysis, or to at least know what kind of additional information you would want to gather on this case.
Is there a length of time that the parent has to have lived in the United States? Is there an amount of time that they have to
Right.
live in the United States? And is there a proximity to the time of the birth of the child?
In this particular situation where you have both parents who are U.S. citizens, then the question is really, did one of them reside in the U.S. at some point? And that's going to be the real question. But the rules about amount of time and when vary depending on how many people are the U.S. citizens in the group. And so in your case, if we presume, we'll go to the U.S. citizens born abroad. These are rules for children who are born abroad, but where the parents are unmarried. So in that case, is it unmarried? Okay, so the question here is, what do we do with this situation? So if there's a child who was born after 1971, and the father was the U.S. citizen, then there are some rules that need to be followed about whether the father can pass on U.S. citizenship in terms of legitimating the child and that information as well. But if the mother is a U.S. citizen, then I think that the information here, the first part is a birth after 1952. If the mother was a U.S. citizen and she was continually present in the U.S. Or outlying possessions for a year before the child's birth, then the child is a U.S. citizen. So as long as in your case you had a U.S. citizen mother living in the U.S. for at least a year at some point prior to the child's birth, then that child would have gotten U.S. citizenship at the point of the child's birth, even though the birth happened in Mexico, wherever else it did. And so really that child is in really great shape, and that's the kind of thing you would hope, an answer you would hope to have when you're looking at a birth certificate for a child born abroad, is to really think about, before you think, are we going to spend a lot of time and effort trying to legalize this child here? The first question an immigration attorney you would want to think about is there some way that this person actually already is a citizen? And just relying on the child's sense of their status or even the parents is not the place to stop, because there may be information they don't have about the laws and how complicated they are that show that they may already be a U.S. citizen. Now, there are also people who derive U.S. citizenship, meaning that they're not citizens at birth, but that when certain things align, they become U.S. citizens. And so these are really for children primarily who are already lawful permanent residents. And we'll talk more about what that means, but they're basically children who have their permanent residency already. If they have their permanent residency, if they're under 18, unmarried, and living in the physical custody and legal custody of their parent, and that parent is or becomes a United States citizen, the child will derive U.S. citizenship from the parent. So what that means is that if you have a child who is a permanent resident, the parent is a permanent resident, the parent naturalizes and becomes a citizen, if the child meets these requirements, the citizenship will attach to the parent and then will flow through the parent to the lawful permanent resident child. And the child will automatically become a citizen without having to go through a process of applying on their own. The other way that this comes up and can be important is in adoptions. If you have a child who prior to the adoption is a permanent resident, under 18, unmarried, and suddenly they get a United States citizen parent via the adoption, as long as the adoption meets federal requirements for having been in place for 2 years, the child can then derive U.S. citizenship through the adoptive parent. So this is why it's really important when you're having a child adopted out of the juvenile court system that the child already be a permanent resident if at all possible. Because if they are a resident already, and I'll tell you how you can make that happen, if they're a resident already, then when the adoption is done with the U.S. citizen parent, the child will become a U.S. citizen, which is really what the adoptive parents in most cases are expecting will happen. But what happens is when the child is not a resident, when the child is undocumented, then that US citizenship of the parent doesn't flow through to the child. It stops and the child is stuck without anything. So this is just a good rule to know. If you have a child who comes into care who's already a permanent resident, you would want to have someone take a look and figure out if there is a US citizen parent, can this child actually be a US citizen, even if everyone involved in the process doesn't realize that that's the case, or that it was the case at the time that the adoption was completed. Now this is just the slide about, the cautionary slide about children adopted by United States citizens. And just the note that I've already talked about, that children might be able to derive US citizenship upon the completion of the adoption, but in many cases they're not able to. And if the child does not have lawful status before the adoption is completed, it may be theoretically possible for the adoptive parents to try to immigrate the child through family-based immigration. But the parents may run into some problems in completing the adoption, but also completing the immigration process. And one of the primary ways this can happen is if the child came to the United States and entered the country without permission, then the child is not going to be eligible, generally speaking, to do their immigration process and complete it here in the United States. And what it means is that the adoptive parents, US citizens, would need to travel abroad with the child back to the child's home country, somewhere the child may not remember and the adoptive parents have never been, and then ask for permission to be able to bring the child back into the United States as a lawful immigrant. And there's no guarantee that the child is going to be allowed to come back into the United States. So it's really shocking for adoptive parents when they realize that this is the situation they found themselves in. And sometimes it only comes to light years after the adoption has been finalized. It may be a time when the parent goes to the Social Security office to apply for a Social Security number and then is told that there is no Social Security number. You can't get a Social Security number for this child because this child has no lawful immigration status in the US. And so I would say that for those of you who work at all on cases of adoptions, it would be, from my perspective, one of the high priority places to make sure you're thinking about immigration issues, because you can very easily address the immigration issues up front, but if the adoption is finalized and that hasn't been done, then the family can find themselves in a world of difficulty. It's not to say it's impossible for them to immigrate the child, but it may be very difficult to do. There is one other way that someone could be a US citizen. It's my favorite part of the immigration law, but it's only been used, as far as we know, one time. There's a provision for foundlings. If you have a child who is of unknown parentage and that's found in the US prior to the age of 5, and there's no contrary evidence that the child is not a US citizen, then the child will be considered a US citizen and you can apply for a certificate of citizenship for that child. We've seen it happen in one case, I think it was in New Jersey about 5 years ago, but it is something to be aware of. If you have I could see a situation where you have a child maybe who was brought here by people who the child believed were his parents, but turn out were not his biological parents, had not adopted him. They don't know who the birth parents are. The child is here. We really don't know the child's background, but we do know he's been here, for 3 or 4 years, starting when he was 3 years old. That child may be able to take advantage of this foundling statute and actually get a certificate of citizenship without going through any immigration process at all, except applying for the certificate. So you should keep it in mind, and you should email me if you find a foundling, because I would be happy to help on those cases, but we very rarely see it. Another way that people can become US citizens is if they are able to naturalize to become a citizen. And what this means is that the person already is here, has lawful status as a permanent resident, and they take a step to become a US citizen. It's a formal application process. For those of you who work with or represent children in juvenile court, people are only able to naturalize once they're 18. So it's unlikely that you're going to see a naturalized US citizen child on your caseload, because that decision is only one the government lets adults make, adults starting at the age of 18. But you may run across families where one or both of the parents are naturalized. Maybe people who are adopting children may be naturalized citizens. Usually people need to be lawful permanent residents for 5 years and then can apply to become citizens. It's a little shortened if you're immigrating through a marriage. And then naturalization has its own requirements. So if you've ever had friends or family, someone you know who is studying for their civics test or their English test, that's probably because they're going through the naturalization process and they need to fulfill certain requirements and pass some tests before they can become citizens. Now the benefits to US citizenship are huge in terms of immigration. You have the ability to vote, to obtain certain government benefits and jobs, like being the President of the United States, as we all know, but you also cannot be deported or excluded from the United States. And so for a lot of people who naturalize, that's one of many of the motivations, is that once they're a naturalized citizen, unless they've obtained citizenship through fraud, they're protected against deportation. They're also allowed to leave the United States, live abroad in Cancun for 20 or 30 years if they want, but they have the right to return to the United States whenever they want. And so it's also an important thing for you to remember, if you're working with children who are US citizens, their parents perhaps are undocumented, are being deported, and there's a decision being made or contemplated of whether to have the children return to the parents' home country. One of the things to know is that that child will always be able to return to the United States if that child is a US citizen. We always suggest you get the child's passport, have all the documentation before the child goes. But the one thing to know is that the child will not lose their US citizenship simply by moving abroad. So that's an important benefit as well. US citizens also can immigrate other family members more quickly, and later we'll talk about family-based immigration and why, you know, if your spouse is going to immigrate you, it's great if your spouse is a citizen, and it's not as great if your spouse is a permanent resident, because the wait times are going to be a lot longer. So lawful permanent residents are people who are here in the United States who've gotten lawful status through either adjusting their status here in the US or consular processing, getting their status abroad. They're also known as green card holders, and not everyone can be a permanent resident. It's just something to be aware of. Often we think, oh, there are 11 million undocumented people here. If people would just like fill out the right forms and do that, everyone could legalize and get their status. And the reality is simply that it's not the case. That for many of the people who are undocumented, there just is no form for them to fill out. There's no form they could complete that would allow them to become a resident, because the immigration law doesn't recognize them as a category of people who can be granted residency in the United States. There needs to be some kind of other basis upon which their residency would flow, and the one way we'll talk specifically is about special immigrant juvenile status, which is for children who are in the juvenile court system. But there may be other ways, family-based immigration, asylee adjustment, other ways to become residents. But it's not simply the case that you can just apply if you've been here for 10 years, which is sometimes we hear that rumor. Or if you've been here 20 years, you can just fill out a form and you can become a resident.
Can I just make sure I
Absolutely.
understand this? So if we have a child who's in the juvenile court who's here unlawfully,
Yes.
and we can get a special immigrant juvenile status for them, that would make them a permanent resident. And then once they're a permanent resident, if they're adopted by United States citizens, they could be naturalized that way. Or after they turn 18, they meet the requirements, then they could be naturalized citizens.
Exactly, and so that's the route, I'll repeat for the video, that's the route for SIJS, which is the goal of the SIJS, the end point is permanent residency for the child. And then that child may be able to derive citizenship from a US citizen parent if they're adopted, or even if they just transition out of the foster care system, once they turn 18 and they make sure they meet the naturalization requirements, they could then on their own apply to naturalize. And so the SIJS gets them part of the way there, and it's a great place to be from being undocumented. It doesn't get them all the way to citizenship at the moment that they're granted, but it does definitely move them along the path to citizenship.
What's the time frame? How long does that average take? I know the starting point is you have to get the order from the court to
Right.
format the particular language and everything.
Right.
Let's assume we have that. Then the next step is the application process then?
Exactly, and so the question is about how long does this whole thing take? And sometimes the concerns are motivated by like, my brother-in-law, it took him 20 years to get his green card, or it can take a really, really long time. Luckily, for children who apply for special immigrant juvenile status, the process is relatively short. It's very short compared to most other kinds of immigration relief. And part of the reason, and I'm going to go into some detail about this later, but part of the reason is that there's a statutory adjudications deadline, meaning that from the day you file the visa petition for a special immigrant juvenile, the government has 180 days to adjudicate it. It's not required to approve it, but it has to do something with it in 180 days. And so the visa petition will typically be approved in under 6 months. And then the question is, how long do they take to approve the residency application? That application is immediately approvable once the visa petition is approved, and we'll go through that more later. Sometimes there can be a delay if the child, they're running background checks on the child and they take a little longer, or the child has to have a medical exam done and it's not completed. But I would say that the typical turnaround time for my own cases is under 6 months from undocumented to being a permanent resident. That time may vary because the Omaha CIS office will adjudicate your cases. So it could be that it takes a little bit longer. It could actually take a little bit less time. And so what I've done at the resource part of the presentation at the end is given you a list of people who handle SIJS cases out of the Omaha office. And you could touch base with them. Kevin Rooser at University of Nebraska does them. And so you could touch base and say, like, how long is it taking them now? But it's not something that you should be worried that the process has to drag out for a year or 2 years. If the applications are filled out properly and all the supporting material is there, then chances are good that you could tell a family under a year the immigration process should be done. It's always good to identify children early on and try to resolve this early, but even if you only identify this issue on the eve of a birthday that's going to cause their case to close, or 3 months before the case may be closing, it's still worth pursuing this, and we'll talk more about the legal protections that you have once you file the application.
I'm concerned, this has not happened to me yet, but in adult cases in the past, if the child has a possession of marijuana charge, how is that going to affect the adjustment?
So the question was about the possession of marijuana charge. And so I'm going to talk in more detail when we go through SIJS about the issues that come up when you have a child with delinquency adjudications. The general rule is that the delinquency adjudications do not bar the child from adjusting status. They do have to disclose them. Even if the record is sealed under Nebraska law or expunged, it doesn't disappear for immigration purposes. So it has to be revealed in the applications. But because it's not a conviction, as long as it's handled in juvenile court, if it's not a conviction for immigration purposes, it won't bar the child getting their residency. But it can factor into the federal government's discretion on a case. So if I have a child who has a drug possession, then I probably want that child to not have another drug possession, and maybe not have another drug possession for 6 months or a year, and hopefully not have an extensive juvenile record outside of the drug issues. But we'll talk more specifically about that. It's certainly the case that if you have a child with a delinquency record, it's a really good idea to have an immigration attorney with some expertise on those issues to handle it, because depending on how Omaha views arrests, it can be a little bit tricky. But it's not going to be a bar. And I handle, I would say, half of my caseload are children who do SIJS through the delinquency system. So I have a lot of experience with those kind of issues. And I would say that we haven't had one denied yet. So you just have to be kind of careful and pick and choose. And this is the other reality on these cases is that it's a huge benefit to apply and to get immigration status for a child. But you only want to be applying if we think there's a pretty good chance the case is going to be approved. Because through an application that is not successful, the child or an adult could wind up in immigration court proceedings and be in a situation that is perhaps worse than when they began. So that's why it's really important to not feel that you have to do the analysis yourself and become an immigration lawyer, but just make sure that there's someone who has expertise who's assisting on the case so that you can make sure that the cases that you file are cases that'll be likely to be approved. And in our office, I've been doing this for about 8 years, and we've never had a case denied. And part of the reason for that is because we're really careful when we screen the cases, and we try to make sure that the cases we put forward are ones that we can be reasonably certain will be approved. Although, of course, we never know, but that's a benefit of the short time frame, is that there's less that can go wrong in the 6 months after you file than if the case goes on for years and years and years. And so it's sort of, I feel very motivated to do them as quickly as possible so that the status quo remains and we don't have arrests and issues coming up left and right. All right. And so some of the benefits of being a lawful permanent resident are the right to live and work in the U.S., like we talked about, the ability, can be very important for children, the ability to access federal financial aid. So if you have a child who's undocumented, that child, even if she completes high school in Nebraska, wants to go on to college, there will be no federal financial aid available for her, whether it's grants or loans. Also, really limited ability to take advantage of government benefits, but obviously more ability to do it if they're a permanent resident. They have the right to work here legally. And it's sort of deceptive, though, because the name is lawful permanent resident. In a way, it's permanent in that the government has given you the status and you're allowed to stay here and work and do these things on a non-time limited basis. But it doesn't mean that you are home free, because people who are lawful permanent residents can do things that make them deportable. And the US government can institute removal proceedings against residents if the government believes they've done something that has created a deportable situation. And so when we talk about the delinquency issues, I'll talk to you about how some of those deportability grounds might come up. But it also may be the case that it's sort of confusing because you have a child who's a citizen, you have a parent who's a permanent resident, and we can't really figure out why is the parent in immigration detention. And that may be the reason why. Although the status is called permanent, the government may be trying to take it away from the permanent resident. This is why it's always a good idea if people are eligible for them to naturalize. Because once they're naturalized, whatever else happens, they at least won't be deportable from the US. But again, it's only advisable to naturalize if you're eligible, because naturalizing causes the government to take a hard look at your case, your immigration case again. So these are some of the benefits of permanent residency, and they're pretty huge, particularly for compared to people who are undocumented. Now we're just going to talk really briefly about refugees and asylees. These are folks that oh, you know what, actually, before we go on to there, I just want you to, if you pull out the materials, just so that some of you can see some documents that are related to permanent residence. So if you have a child or a parent you come across, you can be prepared to look at a variety of documents that may show their status. So if you look at pages 11 and 12, what you'll see here is something called an I-94. And this is a document, you'll see I sort of blacked out my client's eyes on here, but this is a document that is a proof of lawful permanent residency. It's a temporary document, meaning that this document itself expires, but the status itself does not. So this is just something that might be issued. Say the child wanted to apply for federal financial aid and her green card hadn't come in the mail yet. This would be the kind of document you might see that is proof from the government of her permanent residency. If you turn to page 8, you'll see what the new green card looks like. This is as of maybe 6 months ago. The government has a new and fancy green card. This is for a client of mine who was just granted permanent residency this year. If you see someone with a green card, you'll be able, not this one, but you'll be able to tell their name. When you see here USCIS number, what that means is this is an alien registration number. Everyone who has a file with the Immigration Service is given something called an A number. It's a 8 or 9 digit number. And it's sort of their version of a social security number in that it's a permanent number assigned to them that will follow them wherever they go and whatever they do on an immigration case. And so it's an important number to know, particularly if, say, you have a parent who's in removal proceedings and who is detained. If you have that A number, it's going to allow you to access a lot of information about the court hearings and the location of the parent. So it's important to know on work permits and on permanent resident cards that number will appear. What you see in this case is that the child was just granted lawful permanent residence this year, and she's only 17 years old. What it means here is that this child will be able to naturalize to become a citizen 5 years from the date of her approval of her permanent resident status. So in this particular case, in 2016, the child is going to be eligible to become a permanent resident. If you take a look at page 9, this is a sort of client who's about 26 years old or at this point. But at the time when he got his permanent residency, oh, go ahead.
With the lawful permanent resident card,
Yeah.
I see that there's an expiration date of 2/28/2021. Did I understand you right when you said that that card could be expired, but their status may or may not necessarily be
Exactly.
expired?
If you see someone, whether it's page 8 or if you look at page 9 where this permanent resident card expired in 2004, if someone were to walk into your office with either of these cards, either this one that's clearly expired from 2004 or later, it doesn't mean that their permanent resident status is expired. All it means is that the card itself has expired. They're still permanent residents unless the government has taken affirmative steps through removal proceedings to take away their status. And so if someone comes in with a card that is expired and they haven't been in immigration court proceedings, then you can conclude they're still a permanent resident. The question may come up, well, why haven't they renewed the card? You want to be really careful about giving people advice to run out and why don't you just go renew your card? And the reason why is because whenever you renew a work permit or renew a permanent resident card, you submit an application and then the government's going to run some background checks on you when they process the application. And potentially, particularly if you've committed some crimes that make you deportable, it may pop up and suddenly rather than getting your new green card, you get placed into removal proceedings. So if you have folks who come into your office, maybe it's a parent who has an expired resident card, don't jump to any conclusions about why they haven't renewed it. It may be that they don't have the money to do it. It may be that they've just forgotten to do it. But it could actually be that they have chosen not to do it because they don't want to end up in removal proceedings. And as long as they have not been put into proceedings, even if they've committed certain crimes that make them deportable, they're still technically lawful permanent residents. If you have someone who comes into your office, though, with a work permit that has expired, the answer is different. The work permit may be good for a year or two, and when that expiration date comes, it's like a driver's license. You are no, at least I think it's how the driver's license works in California. You are no longer authorized to work. So if your only authorization to work is a work permit and it expires, you're not authorized to work anymore.
What does not having a card mean for them? I mean, how is that a detriment?
You know,
I see there's a number on there too. I mean, can they
right.
say, well, here's my number, my card's expired, here's my whatever.
I think that the way it seems that people run into problems is they apply for a new job, and the employer wants to see a valid card. Even though the employer understands, they may be concerned this isn't really the person whose card it is, there's some problem. So it may come up when they want to get employment. It also can come up if they have, say they have a Nebraska driver's license. The driver's license may be valid for a certain amount of time, and then they want to renew the license. They may, and again, I'm not sure exactly how the DMV would work here, but it may be that they have to show, again, their permanent resident card to be able to renew that. So there's certain things that can create problems if they have an expired card, but their judgment call may be that the problems they deal with an expired card are many fewer than the problems they potentially deal with if they've actually become deportable and they get on the radar of the Immigration Service. So it's just something to be aware of.
In Nebraska, if you don't have valid ID, i.e. a valid permanent resident card, you don't get a driver's license.
Yeah.
It's
So.
like 6 states now that will honor a consulate card, but Nebraska is not one.
So that's a problem that would come up then here. Go ahead.
Would the lost card also affect their ability to exit and return back to the United States?
It potentially would, because they exiting generally not a problem. The government is happy to let you go generally. You can leave, whenever you want. But when you want to come back in and you have an expired card, you would probably face some problems at the border, and potentially you would have the same level of scrutiny as if you tried to apply for a new card, and maybe even more scrutiny. So it would probably limit folks to staying here, but that may also be a judgment call that they make. But certainly it does. With the permanent resident card, you can travel in and out of the country as long as you don't leave for an extended period of time and abandon your status. But they may feel that they're sort of stuck within the U.S., or maybe even stuck within Nebraska if they're concerned about traveling around the country without a valid ID.
Is there a uniform fee for this type of card, for the permanent resident card?
So the question is about the fee. There is a uniform fee, and it's very high. It is over $1,000 for people who are 14 and over. I'll tell you something good news after that, though. And it's just under $1,000 for people who are under 14. The good news about it is that depending upon the basis for applying, the fee may be waivable. And so for the children who are applying for special immigrant juvenile status, that fee is waivable for them. And I've included in the packet a sample fee waiver. So the state shouldn't be worried that there need to be exorbitant costs associated with doing these applications, because the fee waiver can be based, and my sample is based, on the child as a household of one. And any support by the state of Nebraska or by foster parents does not have to be factored in. You're looking at the child, him or herself, and whether they have $1,000 for the fee, and the answer is going to be no. But for other people, maybe who are doing family-based immigration, they may not be able to waive that requirement. And so sometimes that's a reason why it takes them a while to deal with their immigration issues, is if they just don't have the money for the fees.
So that fee is the same in every state?
The fee is the same in every state. And the good thing to know is if you learn this here and then you move to Nevada and set up some kind of practice, Nevada state law is going to be different for you, but everything you're learning here is federal law that is applicable around the country. So the fees, the forms, everything is going to be uniform around the US. Does anyone else have questions about that? Any of these? Anyway, so the page number 9 is just a copy of an old resident card. This is the kind of card that was issued back in the early 90s. And so you might come across people who come into your office and they have an old card like this. And again, what you would see in this case is that his card expired about 7 years ago. It doesn't mean he's not a resident. It just means that he doesn't have an updated card. And he may or may not choose to get an updated card. This, unfortunately, was a child who should have naturalized and did not, and wound up in removal proceedings, and I represented him there. But he did get his immigration status through the juvenile court.
Maybe I missed it. What's the difference between I-94 and
The resident card. The I-94 is usually issued by the Immigration Service on kind of usually a temporary basis. as proof of the permanent residency if there's some emergent reason for it. But it reflects the same status, it's just that usually it's only good for a certain amount of time. It's like a flimsy piece of paper with a photo stapled on it. And so often people, when you apply for benefits or do other things, or maybe even the DMV, may be loath to accept it because they think perhaps you doctored it up at home. So it's always the resident card itself that is secure with biometric data. That's always the best proof of the permanent residency. One other thing just to keep in mind when you, on page 8, if you look at, there's a note that says category. And under there it says SL6. So we're gonna help you decode green cards. If you have someone who comes in, say you have a child, and she tells you like, I don't know, I'm a resident, but I don't know how this happened. What you can do is look at the category on there, and the category will tell you something about how they became a permanent resident. So in this case, the SL6 designation corresponds to special immigrant juveniles. So what that means is that when you have a child who adjusts status as a ward of the Nebraska courts, when they get he or she gets her resident card, they'll have an SL6 designation on it. And so if you have someone who comes in with a green card, they don't know how they got it, you can look at the category, and then either you can call an immigration attorney, or you can actually go on the CIS website and do some searching in their statistical yearbooks, and you'll be able to find the codes, and you can match up the codes to the code on the green card. And so, often people will know how they got their residency, but particularly for children, sometimes there's confusion. And so you can decode the resident card. The same way that you can decode a work permit, and I'll show you how to do that. If someone comes in and says, I have a valid work permit, my mom got it for me, I don't know how she got it from me. And so I'll show you how to do that as well. Let's see if we have anybody else here. This is, on page 10 is just another copy of a green card. It's sort of the most recent version before the current one. And you can see it has a fingerprint on it. This child, when you look at her category, it's actually, you can't read it very well, but the category there is a family-based category. So this was a child who was adopted from Romania, and unfortunately wound up in the juvenile court system post-adoption. But she has a different category on her card, and the reason for that is that she became a resident through family-based immigration. All right, so back to the refugees, asylees. I don't know how often it's going to be that you'll run into refugee or asylee families when you're doing your work, but it's often the kind of immigrants that we think of when we think of immigrants to the US, but they're not a huge portion of the immigrants who are here. It's interesting, though, that I think I have read that Omaha, I think it's Omaha, Nebraska generally, but Omaha has the largest Sudanese refugee population in the United States. And so you may actually run into immigrant and refugee families more often than some other people do. There's also, I put it in the resources, there's this really interesting book about refugees and refugee resettlement in Lincoln, Nebraska that was written in 2002. And it's actually a really great read. So for those of you who are more interested in learning about the refugee, asylee side of things. But just for you to know, these are, refugees are people who have come to the United States with lawful status. Asylees are people who gain that status here, but the fundamental qualification is that they have to have a well-founded fear of persecution in their home countries due to race, nationality, political opinion. So it's kind of the classic immigrant asylee situation. It's a kind of immigration relief that I would say is, from my perspective, incredibly difficult to get here in the United States. Your judges in Omaha, there's a website that lists grant and denial rates for asylum cases. One of your judges in Omaha has a 92.4% denial rate of asylum claims in court, and the other has like a better but 78.4% denial rate. So these kind of claims are complex and often very difficult to win. Even when you apply affirmatively for asylum, and all of your cases would be adjudicated out of the Chicago Asylum Office, still the percentage approval is, would hover maybe around 50%, maybe not even that high. So asylum is generally, from my perspective, a kind of immigration relief that we infrequently affirmatively apply for people. There are some cases that are incredibly strong. My Iranian woman rights activist, we're applying affirmatively for her. But for a lot of children and parents who are here, maybe from Mexico, Guatemala, they may have a legitimate claim, but the risks or the chances they're going to be approved may be relatively low, and if they're denied in the affirmative stage, they will be put into immigration court proceedings. So we always analyze asylum for people, but it's often something we don't choose to pursue because we think that the risks to the family are probably greater than the potential benefits. And so we have the refugees are people who are granted status abroad, and then these are the people who are typically resettled here, the Sudanese population, other folks who are resettled. The asylees are ones who come here on their own and then seek the status once they're here in the United States. They're not permanent residents off the bat, but they are eligible to become permanent residents. And they often will get assistance through the Federal Office of Refugee Resettlement to set themselves up here in the United States, and either after they become asylees here or when they arrive as refugees. Now, there are also people who are temporary legal status holders. These are folks who are not permanent residents, but they have some kind of protected status here in the US. And so if you turn to page 13 of your materials, what you'll see there is another I-94. It's the front and back of a small document. And it shows, this is for a client who came into the United States. If you look at the top part, he came into the United States on January 5th, 2007. And he was given until 4th of July in 2007 to remain. And when you look down at the bottom of the page, what you see is this was a very young child who was a very victim of really serious burns. And so he was allowed to come into the US from Mexico to go to Shriners Hospital to get burn treatment. So this would be a child who's here. He's here with permission, but his permission is limited. There's only a certain amount of time that he's allowed to be here. The government decided to allow him in for humanitarian reasons, but didn't say, come on in, stay forever, but that is what happened. So the child came in 2007, was allowed to stay till 4th of July, and the child was not taken out of the United States on 4th of July. The child remained in the United States. And so what you may end up seeing in some of the cases you have are people who entered the country with permission, but then who overstayed that allotted time that they were allowed to be here. And often for children, these are children who have no say in their crossing of international borders, and so may not have made independent decisions to stay or not. But this is one example of a kind of status here that's a limited one.
Now, since this child is under 18 and he's allegedly overstayed, is he actually overstayed because he's under the age of 18? So how do you handle that?
The question is sort of what do you do with this kind of situation? I think that we would be very hard pressed to argue he's still in some kind of lawful status, but I think that you could argue that any bars or problems that arise from knowingly overstaying your visa shouldn't apply to this child because he was only 5 years old. So there are legal arguments to make to get around some problems, but the reality is that he's not in status, that this doesn't automatically extend somehow just because the child is under 18. So I think that you know, what we do for children like this is SIJS or some other kind of immigration relief.
Isn't there a recent case that addressed this, that came down like 210?
That I'm not sure about. There may be that I'm not aware of. Most of the clients, and it may be that a lot of the children you see are ones who enter the country without permission. So for us, it's more rare that we see kids who come in with status, but there may be something out there. And so what you'll also see is some folk, in terms of parole, which is what this child got, you also may see people who come in on fiancé visas for limited amounts of time, other ways that they're here temporarily. One of the main ones is something called temporary protected status. This may be more common if you see someone who has a work permit but no green card and no other pending immigration application. They might have temporary protected status. And this is a status that the government grants to people often if there's some kind of natural disaster or strife going on in their home country. And the US government says, you're here, we're going to allow you to stay for a while, but we're not going to let you stay forever. We're going to make it sort of time limited. What you'll see here is that Mexico is not on the list, Guatemala is not on the list, so it may be that a lot of the families you're working with just are not going to be eligible for temporary protected status. But certainly for folks from these countries that are listed, it may be more likely you would see someone who has TPS. And the way you would know that is if you turn to page 18 of the materials, you're going to see an employment authorization card. And so for those of you, people say, oh, I have a work permit. This is what they're talking about, or this is what they should have. And again, you would note that this is the kind of document that when it expires, their ability to work expires. So this card on page 18 expired in September 2010. So this person, unless she's gotten a new work permit, is no longer authorized to work. But what you'll see on her employment authorization card is that there's also a category there. It's hard to read, but the category for her is A12. So that tells you, okay, there's some kind of code, there's some kind of way for us to do some detective work and figure out what is this person's status. So if you turn to page 15, I've given you the decoder list, and this is a list of different codes that are used on work permits to show what someone's immigration status is. How is it that they have a basis to get a work permit? And so what you see on page 15 in the middle of the page is that the code A12, and that's going to correspond to the 12 in parentheses, is for someone who has temporary protected status. And so what you see from the work permit you looked at is that this is a woman who is here from El Salvador, is it? Yeah, she's from El Salvador, and the way she got her work permit was through temporary protected status. So this was another way to help you sort of decode some documents that may come into your office, aside from calling an immigration lawyer, being able to at least to do some basic detective work.
So these people, while they're here then, I mean, is it like hurry up and apply for permanent status then, or?
So the question is, you know, they're here, they've got this protected status, is the idea like hurry up and apply? And the answer is generally there is nothing more for them to apply for, because the government temporary protected status program is one that doesn't create a path to permanent residency on its own. And so there is no, unless they have another form of immigration relief that's available to them, there's no next step for them. And so some people remain in TPS status for years and years and years, because the government keeps extending TPS and they keep reapplying. But there is not a next step for them to take unless the law changes and there's a path that's created. It's not the kind of situation where they can just go ahead and apply.
So are most refugees then temporary protected status? I mean, like you said, we have a big population of Sudanese.
Right.
Are most of them in this status?
If you have refugees, like the Sudanese population, generally those are going to be people, I would say, who are granted refugee status before they arrive in the US, they're here, and they actually can apply to become permanent residents after a year. So their refugee status is separate from this program, which is temporary protected status. And the temporary protected status is only for these designated countries, which includes Somalia but don't include Sudan. So I think that it would be unlikely that you would have a Sudanese family with this status. It's more likely they would be in a refugee status. And again, that is a bit more of the hurry up once you get to the year point and you can apply. As long as you're eligible, it's probably a good idea to do that. All right. And then we have some people who are non-immigrant visa holders. These are people who came into the US for some particular reason. You may have had a foreign exchange student in your home on an F1 visa. You may have people who came into the country on a B visa. These are visitor visas. And so if you turn to page 20 in the materials, what you'll see there is a copy of part of a passport. And this is actually a visa that was issued abroad for a child who came into the United States. And so on there you'll see this is a visa that was issued by the US government in Phnom Penh. And it's a visa that allows the child to come into the United States. The visa itself, and this is something just good to know generally, the visa itself is a document that's used for entry into the US. It's not a document like this kind. It does not reflect how long the person can stay. So when you look at this document, what you can tell is that starting on January 17, 2002, this client could come into the US, and he was allowed to come in any day until until April 16, 2002. So he had a short window where he could arrive. But that doesn't say anything about how long he could stay. In his particular case, I think he was given 6 months to stay. The visa is just the arrival document, it's the entry document, but it doesn't tell you how long you're allowed to be here. So if you come across someone like page 22, this is a border crossing card. This is basically a visa or a visitor card that allows you to come into the United States. It's often given to people who live in border towns who travel back and forth frequently. When you see this card and it says visa is issued September 14, 2001, and the visa expires September 13, 2011. If this child entered in 2002 and never left, he is not in lawful status under this visa. The expiration date of the visa is simply the date that he can use the card until to come back into the country. It doesn't mean that the government has given him 10 years to live in the United States permanently. So again, these kind of visas are telling you when someone could enter, but they're not telling you how long it is that they can stay.
So, I know of a situation where someone had a student visa and then they're graduating and they became a resident alien.
Mm-hmm.
How, the expiration date on their card is when they're done, basically, they have to leave.
If the
Unless they pursue, what would the next route be?
Route be for them?
Citizenship?
So the question there is you have someone who came in on a student visa, they became a permanent resident, but their card expires after 10 years. no matter how they started off, once they become the permanent resident, the status is permanent. If the card expires, it's exactly what we were talking about. It means the status doesn't expire, it's just the card itself. For that person, the next thing they could do, if they're eligible, is apply to naturalize to become a citizen. But they've already gotten over the temporary hurdle, they've gotten into the resident mode, and now they potentially can move on to the citizenship.
And the resident alien card, that's a shorter amount of time than the permanent resident?
They're the same thing.
They're the same.
Yeah, if the person's a lawful permanent resident, that's why in the samples here, one of them is called resident alien, one is lawful permanent resident. Those all mean the same thing, and so that's why if you see the samples, there's sort of different lingo, but the status is the same. Okay. And then we have the last but not least, undocumented people. So these are the people, you hear that the illegals, aliens is the official term in the immigration law itself, but basically these are people who are here in the country without permission. They may have entered the country without permission. They may have been brought over as babies or snuck in. But they also may be people who enter the country with permission and who've overstayed the amount of time they're allowed to be here. So their status is expired and they're here without any immigration protections. And now without an avenue to become a permanent resident or get some kind of lawful status here, they're not allowed to work legally in the US. They could be subject to deportation, going through removal proceedings. And so it's sort of the least desirable immigration category for anyone to have. It's the kind of status I would have if I moved to Mexico, went there as a visitor, stayed for 5 years, and had no way to, even if I lived my life in Mexico for 10 years, and I presume I know something about Mexican law, it would be like you would move to a different country that you love and would want to be there. But unless you have some mechanism to legalize yourself, you're going to have a lot of problems. And so particularly for children, and we'll talk specifically about kids in the juvenile court system. Mm-hmm.
I do have a question actually.
Oh, okay, I thought it was doing something wrong with the video.
I am a H-1B holder,
Mm-hmm.
and to refer to her question, I don't think a resident alien is equivalent to a lawful permanent resident. You can only be a lawful permanent resident if you apply to adjust your status from an F1 visa or a H-1 visa. But just to get a resident alien status, you just have to be here for more than 5 years and you would get to be a resident alien. But that does not mean that you are a lawful
Permanent resident. Okay, so there's a correction from the videographer about the resident alien status. And so on the card that I showed you that says resident alien, that one is a lawful permanent resident, but it sounds like there is an intermediary step for people who may be on H-1 or student visas. And that's not something that I have familiarity with, although there are a couple immigration lawyers here who may be able during the break to give you more info on that. But that may be a interim kind of status that I'm not sure how the person would take a next step on. Okay. All right. So when we're talking about kids who are undocumented, and we'll focus specifically on children who are in the juvenile court system, the issues that come up for them are many, but they're often concerns about having immigration holds put on them, being deported from the United States, no matter how long they've lived here, an inability to get a social security number or to get any kind of ID from the state of Nebraska, really limited access to government benefits, some, I think, limited ability to take advantage of independent living programs. And I don't know, depending on the funding sources, there may be limitations, but also just the practical limitations of if independent living classes and programs are designed to help you apply for college, but then you have a problem paying for it. Or they're designed to help you get you out in the workforce, but you have no way to work legally. You as folks who work with the kids and the children themselves often will butt up against a huge number of hurdles when they are undocumented. And unfortunately for some of the children in the system, it's only upon their entry into the system that they learn that they're undocumented. A lot of the children I work with have been here 10 years, 12 years, and they actually have no idea what their immigration status is. They have believed they're a US citizen for a long time, but when they enter the juvenile court system, that's a time when you need a birth certificate, we need some explanation, and it may be at that point that their immigration status comes to light, not just to you, but to themselves. And so all these hopes or dreams they may have had of what they were going to do with their lives become compromised if they don't have some kind of lawful immigration status here. And so one of the things that I think is why this is a particularly good time for all of you to be thinking about immigration issues is that my understanding, I don't know if, Kelly, you can tell me if it's been signed, but my understanding is that the Legislative Bill 177 is on the desk of the governor, which is a bill that deals, I think, with sibling placement, but also has a provision about independent living or transitional living plans for children in the juvenile court system who are 16 and over. And so some of the things that are addressed in those plans are education, employment, healthcare, managing your financial assets, housing. And so what you can see is for undocumented children, trying to work on a case plan with them, if that's your job, is going to be a difficult thing to do because almost all of those areas are in one way or another going to be impacted by the child's immigration status. And so in a way, when those case plans, if and when they need to be created, to really think about what is the child's immigration status and is there a way to gain lawful status for the child as soon as possible before they age out of the foster care system. And particularly for special immigrant juvenile status because it's a kind of relief that's only accessible to the child when there's an open juvenile court case. And so what we're going to do now is I'm just going to spend about 15 minutes talking about the basic requirements for SIJS, and then we're going to take a break, and we'll come back and talk more in detail about it. Go ahead.
For undocumented people, is there any ID that they can get? Because I have 2 kids who have some sort of ID that they've gotten from immigration offices in Omaha, but they tell me that they can't do anything with it. It's just a document that says who they are. Like if they were, if they got pulled over for driving or whatever, it would be an ID that they could show. But they couldn't go and get a driver's license with it. They couldn't do anything like you can with a state ID, but it's just an identification.
Something. So if you guys look at page 23 of the materials, I don't know that this is what they have, but it may be something that they have. This is a consular ID card. It's a document issued by a government, an official government document. It's just not the United States government, and it's not the government of Nebraska. It's an ID card issued by the foreign country where the child was born. And so there is a Mexican consulate in Omaha, and there's a Guatemalan consulate in Chicago. And both of those places may be able to issue ID cards for children to at least have some kind of identification. But there are two caveats to that. One is that it can be difficult to get foreign passports for children if both of their parents are not involved, because the government may be concerned about international child abduction. In the same way it's hard to get a US passport for a child unless you have consent or involvement of both parents. You may run into some problems trying to get foreign passports for children, but at least the consular ID cards may be a little easier. The other thing to know, just as a general rule, is that if an undocumented person is stopped by the federal government, questioned by immigration agents, and they're undocumented, the only evidence the government needs to successfully put them into removal proceedings is evidence of the person's alienage, meaning where they were born. And so just an important thing for people to be aware of is that if someone is stopped by a federal immigration officer and they present their consular ID card, they are basically giving the US government all the evidence it needs to put them into removal proceedings and to deport them. So it's something that, having the ID can be incredibly useful, but along with the ID, people might want to have some information about the significance of using the ID. But certainly I think you cannot apply for a Nebraska driver's license with it. You can apply for public benefits that are not available to undocumented people. But honestly, for some children who feel like, I don't even know who I am, I don't know where I came from, sometimes having an ID like this is helpful, even if they don't carry it with them, just for them to feel like they have something. Because a lot of the kids that I work with just feel like, I don't know my home country, I can't get an ID, maybe they have a school ID. So it can be useful, but I suspect it may be something like that they have.
Because there is some things that the undocumented user
Able to
can still get benefit-wise, they would have to have some kind of
identity.
card for.
Right.
And so we run into that problem, so that's why it's been nice that they've been able to get those.
And I think that it's depending on how many children you're working with and what you want to do as a state, but I do think that there have been successful collaborations between state agencies, child welfare agencies, and consulates where there have been MOUs or just informal agreements where the consulate is willing to work openly with the child welfare agency to help children who are wards of the state and maybe make it a bit easier to get the consular ID cards, perhaps some help with getting birth certificates or death certificates of parents. I think that the consulates seem often more open to working with agencies than they may be to working with individual people. And so if you're part of HHS and you know that a lot of kids in the system could benefit from these cards or you might need consular services, really setting up like a formal meeting with the consulate, not about any specific emergency case, but just about how can we work together, the consulate and child welfare, may be a really good idea. So it's just something to keep in mind. And for the Mexican consulate, it is in Omaha, so that would be pretty convenient. The Guatemalan consulate, again, I think the closest one is Chicago, but still they do seem interested in being involved, so I would think that reaching out to them would not be a bad idea. And again, other consulates, depending on where they're located, you could do that as well. But for special immigrant juveniles, this is the one form of relief that, besides the HHS attorney who identified himself, has anyone else worked on a special immigrant juvenile status case? Anyone here? No, okay. So this is going to be brand new for you, but really important to know about. It's a kind of immigration relief that's been around since 1991, but very few people know about it. And so you'll come out today with a bit of, you can feel like it's expertise or at least information about SIJS. It is a route, like we talked about earlier, for a child to be able to become a lawful permanent resident. So it can take an undocumented child, or even a child who's here on some temporary basis, and turn that child into a permanent resident, as long as the child meets some very basic requirements. And so I've reproduced for you, particularly for the attorneys if they're interested, at pages 47 to 49 are the statute and the regs on SIJS, and they're surprisingly short and sweet, so it's easy to check them out. Another thing you might want to look at is, in your leisure time, is page 100 is a letter it was from 2006 from a CASA publication. And it's a letter from an official at the U.S. Citizenship and Immigration Services, basically encouraging child welfare agencies and juvenile courts to seek special immigrant juvenile status for children. It is a form of relief that the government, I would say generally, is happy to give to children if they can, not always, but much more than other kinds of relief. But the reality is that very few of these children are legalized every year. I did my statistics from 1996 to the present, and starting in 1996, there were only 390 cases around the entire country of children who became residents through SIJS. And we think we've made like miraculous progress because last year we had 1,492. So it's, you know, it's quadrupled, but the reality is when you think about 1,492 children versus the probable population of undocumented children in the child welfare system, I think that this is only a tiny percentage of potentially eligible kids. And I think that honestly the biggest hurdle here is that there was really no federal implementation of this law. There was no outreach that was done or funded in any significant way to even notify people who work in the juvenile courts about this kind of relief. And so unfortunately, even though it's incredibly beneficial, it's something that most people don't know about. And so many children, I'm sure, and I'm sure in Nebraska, every state, have gone through the juvenile court system and could have been eligible for this, but no one knew about it. It only takes one person. It takes a CASA or one attorney or the judge to even be aware that it exists. And sometimes that's all you need to do. It's just, you know it exists and you think the child might be eligible. That may be enough to refer the child to a legal services immigration provider who could sit down and assess the case and at least help you going forward. But if no one on the child's case knows about it, it's highly unlikely the child herself is going to have any idea. And so the child will go through the child welfare system and come out the other end as an undocumented person when it was easily preventable. So we're going to prevent that from happening for the kids that you work with. One thing to note is that there were some recent changes to the SIJS statute, but luckily for all of you, since you haven't done a case before the changes, we won't spend a lot of time on what the changes are. I'm just going to talk to you as we go through it about what the law is now and spend a little bit less time talking about how the law used to be. But one of the things you will notice if you take a look at the regulations is that they're very outdated. The law was passed in 91, the regs were only updated in 93, and you have a statute that was most recently amended effective 2009. So when you look at the statute and the regulations, you're going to see some discrepancies, and that's because the federal government moves very slowly on promulgating regs for this kind of relief for some reason. So you just want to be aware that you may feel like you're getting some mixed messages through the law, but to know that the statute is obviously going to govern and the regs may be a bit outdated there. Now these are the basic requirements for SIJS, and I'm going to go through each of them in some detail, and I'll probably get through one or two and then we'll take our break and I'll finish up after the break. But these are the basic eligibility requirements. A child has to be under jurisdiction of a juvenile court, dependent on the court, or their custody somehow committed to a state agency or to an individual. And this is a change. The bolded are the recent statutory changes. The court has to find that child cannot be reunified with one or both parents due to abuse, abandonment, or neglect, and also that it's in the child's best interest to remain in the United States. The thing that's really unique about SIJS is that if the child meets all these requirements, it's not enough for you or for me or for someone else to think. The only person who can help the child in agreeing these requirements are met is the judge who's sitting in the corner. Because for SIJS cases, you have to have a state court order making these findings that the child meets these requirements. And if you don't have those findings, then you can't apply for this benefit. So the first step and the most important step, and we'll go through case by case, but the initial and important step in the juvenile court is getting an order with these findings, because if you don't have the order, there's nothing more that you'll be able to do. If you turn to page 37 of the materials, you'll see that there is I brought a sample from California. We actually have a judicial council form, an official form approved by the California Supreme Court. And it's for use, I marked it up because it's outdated because of statutory changes, but it's for use in SIJS cases in California state courts. And so it's a form that can be used on dependency cases, delinquency cases, and it's actually been incredibly helpful to have the form, because there are often judges who have never had an SIJS case before, and they may be concerned, like, what is this crazy thing you want me to do? Should I be doing this? Is this allowed under Nebraska law? And so having a state form that actually a judge could use on an SIJS case is really helpful. So I suspect that maybe that will be in the works in Nebraska at some point. And if it is, I think as attorneys filing these motions, it'll make things a bit easier for you. But I did include in the materials, I think it's at pages 30 to 36, Kevin Rooser from University of Nebraska in Lincoln gave me these materials that he had. And these are, this is a sample SIJS request for a juvenile court here in Nebraska. And this was one that was handled in 2008, so it's prior to the statutory changes, but at least it's for you to have a sense of the kind of things that have been presented to judges here in Nebraska for their signature. But again, it's just important to remember the state court order is essential. Without that, even if the Immigration Service wanted to approve the case, they would not be able to do it without the order. Yes?
I've actually run into this several times where the parents are being deported when they have a kid in juvenile court. But my question is, we get one of these, they get spatial status, but when they turn 19, which is when they're an adult, what is their status then?
This is a question about what sort of happens. You have the child who gets this status when they're under 19 or they're under 18, they're under juvenile court jurisdiction, but what happens once the case closes out? The great thing about SIJS is that it extends beyond the life of the juvenile case. So you have to file for it while the child is under juvenile court jurisdiction. But if the case is granted, that child goes on to be a permanent resident as long as they don't do something to become deportable, and they can actually apply to naturalize to become a citizen. So it actually affects the child's immigration situation for the rest of their lives. It's not a temporary thing where they say, you're legal while you have an open court case, and then once your court case closes, you go back to being undocumented. That it'll be a permanent status. One thing for people to know is that a child, because of the requirements we'll go into, a child can't transfer an immigration benefit to a parent if they've become a resident through SIJS. And the reason being that the SIJS is based on having been abused, abandoned, neglected. And so Congress said, we're gonna benefit this child or these children, but we're not gonna allow these children to turn around and to create an immigration benefit for their parent. This is only something that will benefit the child, but it's something that will permanently benefit the child. So that whenever the case closes, that's not gonna create a problem in terms of the child's immigration situation.
Now, once the child is given this benefit, and then they become old enough, 18 to naturalize, and then when they come 21, they're U.S. citizens, do
Right.
they not bring their parents over?
So the question is, once the child, they get their green card this way, they become a citizen, and then they are generally people, when they're U.S. citizens 21, are eligible to apply to immigrate family members. And so the question is, if the child gets SIJS, becomes a citizen, and then wants to immigrate the family members, I think if the Immigration Service actually reviewed the file carefully and knew about SIJS, they would deny a family-based petition for a child who is trying to immigrate a parent. But practically speaking, I don't know what would happen because I think these cases, as you see, are so rare. I'm not sure that what would happen there, but I suspect that if all the information were known to them and they did the legal analysis, they would deny that application. I think the question that's tricky too, or could be, is can they immigrate siblings? Because the government may say, well, if you immigrate a sibling and the sibling turns around and immigrates the parent, aren't you getting an end run around the parent? I think that that hasn't been tested. I would say that you could immigrate a sibling. If a child got SIJS, they could, upon naturalization, try to do family-based immigration for a sibling. But that, again, is sort of, we haven't had a case like that. Often when you have sibling groups, it's often the case that some will be citizens and the ones who aren't together will all become residents through SIJS. It's I think, a little bit more rare, or at least in my caseload, that you would have only one child of the family who may qualify for SIJS and the others don't. But again, it certainly has happened. But it's something to keep in mind. So it's 10:45. We're going to take a break for 15 minutes, and then we'll come back, talk about SIJS for about a half hour, and then we'll expand into family-based and some other kinds of immigration.